Oh, right. Because he may have different. I think we've got him ahead, so we can organise his notes on exactly.
All right. Good morning, all. We're here for day 2 of the hearing and the matter CFI 2, 2016, before Deputy Chief Justice Sir David Steele. The claimants represented by DLA Piper Middle East LLP. Lead counsel is David Thomas QC. The defendants represented by Allen and Overy LLP. Lead counsel is Christopher Mainwaring Taylor, assisted by Yassine Francis.
Yes, good morning.
Morning, my lord. One point of housekeeping. The parties reflected on the core bundle, and our joint view, subject obviously to your view, is that we're best off abandoning the core bundle and simply sticking to the...
Well, I fear that disappointing though it is in terms of carrying stuff about, it looks like the only option.
I think it's the practical course. If it's any consolation, I think the heart of the matter is probably in bundles 8 to 30.
Yes. Well, it may be I will create my own core bundle.
Yes, indeed.
By simply extracting from the bundles. So actually what I might ask for is a file which contains dividers numbered 7 through 13, which will be the bulk of them.
Yes, yes.
And then I will in due course extract what we've looked at, or are going to look at.
I mean, one option is that the parties assist you by producing a bundle, an agreed bundle, hopefully, when we've done our written
Well,
closings.
that's another possibility. The only drawback to that is that, of course, I would have marked up my copy. Anyway, let's see how we get on.
Yes.
Okay.
But I think then from here on we won't refer to the core bundle, and we agree.
I'd be grateful for that. There was always a risk anyway of seeing the same document.
Exactly, it's confusing. And we've also agreed that, again, subject to your view, we will go through the transcript and change any core bundle references.
Which reminds me one thing. Please, thank you for that. Please, could I have a copy of the chronology and annotated with the cross-references, please?
We'll secure that for you.
Thank you.
Well then, if there's nothing else without...
No, let's get on.
Yes,
Yeah.
I'll call my first witness, Mr. Musaba Al-Mahiri.
Could you please state your name and your address for the court?
My name is Musabbah Salim Musabbah Hamid Al-Mahiri, and I live on, I'm from Abu Dhabi. I live on the Palm, Junair, L92, Villa L92.
Okay, thank you. Please place your hand on the Quran and take this off.
I swear by Almighty God that the evidence that I am about to give is the truth, the whole truth, and nothing but the truth.
Thank you.
Amen.
Please direct your answers into the microphone and towards the judge.
Good morning, Mr. Al-Mahiri. Is that
Good morning,
what
Your
I should call you? Please sit down.
Thank you.
It's obvious English is not your natural language. If you have any trouble understanding what people are saying, will you please say so?
Yes, Your
And
Honor.
if you have some trouble in expressing yourself, will you please say so?
Thank you, Your Honor.
And lastly, can I ask you to treat me like a very old deaf man and speak up, okay?
I understand. Your Honor.
Thank you very much.
Mr. Al-Mahiri, good morning. I hope you have with you there a bundle of witness statements helped to it. And I'm just going to get you to confirm your witness statements and make any corrections that you may have. Now, you've given 4 witness statements altogether. Could you look first, please, in that file at divider 11? Have that?
Yes.
And so we see there a witness statement with your name on it that's dated the 18th of January 2016. And I think it's right, you gave that for the purposes of the injunction proceedings a little over a year ago, didn't you?
Correct.
And if we turn to the end of that statement at page 31 of the statement and of the file,
Page 51.
page 31 of the document, you see a signature there.
Yes.
Is that your
correct.
signature?
Yes.
And is this statement true and accurate to the best of your knowledge and belief?
Correct.
Then if you turn on to the next divider in the file, please, divider 12. We see another statement that you made, second witness statement, dated the 1st of February 2016. And if we turn to the last page of that, which is page 19 of the document, 230 of the file, and is that your signature?
Correct.
And is that statement true and accurate to the best of your knowledge and belief?
Correct.
And then you've given 2 statements specifically for this hearing. If you turn on to divider 13 in the file, of your witness statement dated 16th of January this year.
Yes.
I understand you want to make a correction to that statement, or in fact 3 corrections to that statement. I understand that the first correction is to paragraph 22. So could you turn to that, please?
Yes.
Do you have paragraph 22?
Yes.
Could you tell His Lordship what correction you want to make to that paragraph?
In the middle it says NBD letter also requested that I provide an update on the progress of my negotiation with a potential buyer in relation to my intended sale of the project. To be clear, I never suggested, that is not correct, to NBD that I intended to sell the project. I have always told NBD that I will sell the project, complete project. Nor that I was negotiating with a possible buyer. I was negotiating in November and December 2013 with His Highness Sheikh Sroor. And I have produced a letter from His Highness Sheikh Sroor, which I've taken to NBAD and delivered it at 3 o'clock in the afternoon on the 22nd floor to Mr. Thomas Longo and Nelson. But I forgot completely to take a copy of that and to keep it for my records. So I have no recollection of that, and I regret making this statement.
Then I understand that you want to make a correction to paragraph 29. Is that right?
Correct.
What's the correction you'd like to make to paragraph 29?
Well, I would be content, I think, subject to any objection from the other side, that you led him on this if there are some corrections that he's discussed with his legal representative.
Yes. Mr. Al-Mahiri, I'm very grateful. Mr. Al-Mahiri, I think if we go to the middle of the paragraph, we can see a sentence beginning, I never produced such a letter to NBAD, and that's beforehand, I assume such expression of interest received would have been as a result of NBAD's inquiries of such interest in the market. I note the document records that the client has produced a letter from a potential buyer. So that's,
I did produce the letter.
so when you said I never produced such a letter to NBAD, the correction is that you did.
Yes, I did produce the letter. I have taken it from His Highness Sheikh Sur's office in a brown envelope, and I have given it to them.
And then I think you have a minor correction to make to paragraph 43. And to the third line, we can see that you refer to E.C. Harris was subsequently appointed, I believe, in or around March 2014. And I think you want to correct that date of March, don't you?
That is in June.
June, yes. Thank you.
That's not March.
I'm so sorry, that was paragraph 49, was it?
43.
43, I'm so sorry.
The third line of paragraph 43.
Yeah.
I did the sort of document yesterday. So
Thank you.
and then if we turn on to the end of this statement, at page 51, 283 of the file, do we see your signature again with the date of 16th of January? And subject to those corrections, is that statement true and accurate to the best of your knowledge and belief?
Correct.
And then you made a second statement specifically for this hearing. If you go to divider 19 of the file, of your second statement there, dated the 9th of February.
Yes.
And I understand that you want to make a correction to paragraph 22. Have that?
Yes.
And I think you want to correct the dates in the first line, don't you?
Yes. I left on May 1st, Your Honor, and I returned on the 2nd of May.
Yeah.
Yes, thank you. And then turning to the end of that witness statement at page 13 of the statement, your statement, your signature again, and is that, subject to that correction, is that statement true and accurate to the best of your knowledge and belief?
Correct.
Now I want to ask you just about one clip of documents that arrived in this case in the last day or two. Be given file 13, please. And could you turn in that to divider 229A? Have that?
Yes.
And what we can see is an email from Mr. Mahfouz Shuhaiba of Intermas, dated the 4th of May 2015, to Mr. Sokan of NBAD. And under the CCs, we can see that it's CC'd to Mr. Thursby and to yourself. Did you receive this email?
No, I did not, Your Honor, see this email.
Is the email address correct?
No, Your Honor, it is
What
not
should-
addressed correct.
What is the correct email address then?
It says my email is msalmuhiri@mailme.com. It's .ae, Your Honor.
Yeah.
Did you see this email before, at any time before this week?
No, I never saw this email before.
And if we turn over to documents that are attached to it, if you look at the next page, there's a modification permit. And do you see that there's a client name of Sheikh Sultan Sakir Sultan Selim Al-Qasimi? Pronunciation, but is that a name that you recognize?
Yes, I do, Your Honor.
Go on.
He is the majority partner of Intermas. He owns 51%.
Yeah.
Thank you, Mr. Al-Mahiri. Gentleman to my right will have some questions for you.
Thank you.
Al-Mahiri, I'm Yassine Francis, in this matter. I'd like to talk to you first about Mr. Blow. Mr. Jean-Sébastien Blow was your employee.
Correct.
Mr. Blow was familiar with the status of the project.
He was the finance manager.
Familiar with the day-to-day, the week-to-week, the month-to-month progress and status of the project, is that correct?
To a certain extent, yes.
He liaised with NBAD on your behalf, that's correct.
Correct.
You did not call Mr. Blow to appear as a witness in these proceedings.
Are you asking me the question, please?
Well, you did not ask him to appear as a witness in these proceedings, is that correct?
Correct.
I ask you to be given volume 8 of the bundle, please. Turn to tab 107, please. Go over the page. Do you see there's an email from Mr. Blow dated 23 April 2014. The date just appears on the first page. It's broken over the page, which attaches the Intermas program. You see, back to the first page, it's copied to, sent to Ms. Shocker and Mr. Sokon of NBAD. You see the email above, forwarding the Intermas program to others at EC Harris, as well as Samantha Woolley, who originally received it. There's no record of you or Mr. Blow making any comments to NBAD on this Intermass programme, is there?
That's correct. We received it and we basically handed over to NBAD.
Can I ask you to turn to tab 108, please? Over the page, you see this is the EC Harris Development Budget Estimates, issued on 28 April 2014. You saw this EC Harris Development Budget Estimate at the time it was issued, didn't you?
Yes, I have.
Turn to page 1635. You see here, under the heading Observations, section 5.1, EC Harris provides its opinion on the completion date shown in the Intermass programme. And it says, the overall timescale indicates a revised date for completion of 20 December 2014, plus commissioning. We would estimate a further 12 weeks for this activity, equating to a final completion of the end of March 2015. This contrasts to our estimate judged on the observed outstanding works of May 2015, and thus we feel the contractor's programme could be slightly optimistic, but not overly so. Now, there's no record of you providing any comments to NBAD or EC Harris on those EC Harris observations on the estimated completion date.
No, we are not specialists in programs.
Can I ask you to turn to tab 113 in the same bundle, please? This is the facility advice letter dated 28 May 2014, and over the page you see that it's signed by you. I just want to draw your attention to point 4 on the first page. From point 4, it's correct that you were aware that loan repayments would start in December 2015.
Yes, I have signed this and I read it.
So you were aware that loan repayments would start in December 2015?
Correct.
And point 7, you were aware that a key term of the new loan was that you would appoint Hill International or Turner Middle East Construction as project manager within 1 month of the facility advice letter.
Correct.
I ask you to turn to tab 115 in the same bundle. This is a letter from you to Mr. Sokon dated 15th of June 2014, and you were enclosing a copy of your contract with Hill International as the project manager. I just ask you to turn to page 1681. Just draw your attention to section 1.1.11, which shows the time for completion. Now, it's correct that you agreed that the time for completion of the project manager's appointment would be 28 February 2015. That's correct, isn't it?
That is the contract for Hill International.
And it was due to expire from the outset. It was due to expire on 28 February 2015.
Correct.
Moving on to the amendment and restatement agreement, which I'll refer to as the restatement. It's correct that you signed the amendment, the restatement.
Correct, I signed it.
You say in your witness statement you did not read the restatement before signing it.
I did not read it. I left it for my lawyers to do the job. I'm not, a lawyer to read all the finance agreements or any long agreement for that fact.
Can I just ask you to be given volume number 6, please? And if you could just turn to page 1109, please.
Lima.
Okay, this is At the bottom of that page is the
Sorry,
development.
repeat the page, will you?
Page 1109.
Thank you.
See, clause 22.5 is the development completion application.
This
And-
this is the reinstatement agreement, the finance agreement?
The amendment and restatement agreement
yes.
dated 28 September 2014.
Yes, which I did not read, I told you.
You did sign every single page of this agreement, didn't you?
Yes, I did.
And that's your signature just below the development completion clause, isn't
Correct.
it? You said you relied upon DLA Piper to review draft versions of the restatement, but also Mr. Blow was reviewing draft versions of the restatement on your behalf as well, wasn't he?
He was coordinating. He's not a lawyer. He was coordinating with DLA.
So you didn't expect him to review any draft versions of the restatement?
I did not expect him to be acting like a lawyer.
Did you expect him to read every page of the restatement and then advise you of any significant terms that should be drawn to your attention?
No.
Were you aware that the drafts of the restatement that was sent to Mr. Blow and DLA Piper from 9 July 2014 onwards included the obligation on you to procure completion of the project by 31 March 2015?
Absolutely not.
Not aware of those emails. I'll just take you to one. If I can just ask you to be given volume number 9, please. Centre tab 121, please. See, this is an email from Ms. Shocker of NBAD to Mr. Blow on 9 July 2014, which attaches a draft version of the restatement. And if you look over the page, you can see this is an extract from the draft restatement that was attached to that email. And you see, marked up in track changes to clause 22.5 is the inclusion of the 31 March 2015 completion date. You see that?
In the second page.
Yes, page 1759.
Okay.
Track changes under development completion. Crossed out is the previous wording. And the new addition is 31 March 2015. Development completion date. You see that?
Yes, I see it now, but I didn't see it then.
If I can just ask you to turn to tab.
So who is Mr. Sebastian?
Your Honor, he's finance manager, and he was coordinating between NBAD and DLA.
Okay.
Turn to tab 136, please. See, this is an email from Mr. Blow on 17 September 2014, titled Das Real Estate Final Comments. And you see, this is Mr. Blow relaying the final comments left from our lawyers in the first line of that email. Do you see that?
I'm sorry, are we in... I do apologise. 136 are we in?
Yes.
Is there an email from Mr. Sebastian?
Yes. That's Mr. Blow, Jean Sebastian.
Oh, I see. There is Mr. That's thrown in. I'm so sorry.
Apologies, Ron.
My fault. So that, otherwise I wouldn't have asked the question. I hadn't appreciated they were the same person. Right? Thank you.
So the question is, this is correct, that this email shows Mr. Blow liaising with NBAD, passing on comments from your lawyers, DLA, on the draft restatement. That's correct, isn't it?
Correct.
As far as you're aware, DLA Piper did not raise any issue in respect of the completion date of 31 March 2015 before the restatement was signed.
Correct.
Staying in the same bundle, flipping back to tab 129. email from Hill International dated 10 August 2014, which attached the Hill International executive briefing paper, and we see the document is copied to you and Mr. Blow at the top. But it's correct that this email was not sent to NBAT.
This email was not sent to IMBAD. I don't see IMBAD being there.
Yep. And you're not aware of any email or copy of this document being sent to NBAT?
Correct, I am not aware of that.
And if at the bottom of the email you see Hill International are saying, if necessary, hard copies of their executive briefing paper can also be provided for all attendees at the meeting scheduled for 3 p.m. today, but only after receipt of approval for general circulation has been received from your good selves. It's correct that there is no record of you providing that approval to Hill International.
Hill International would have automatically gave E.C. Harris. They cannot hide anything from E.C. Harris. They would have given it to E.C. Harris. I'm 100% sure, Your Honor, of this.
That wasn't quite my question. My question was, there's no record of you giving Hill International the approval which they mention in this email.
On the 10th of August, Your Honor, I was not in UAE. I was in Cyprus attending the burial of the father of a friend of mine. So there was no, I did not carry the computer to the graveyard.
So based on that information, it's fair to assume that you did not give any approval in response to that email.
Correct. I did not give George the approval for communication with him to basically give hard copies to all attendees.
I ask you to turn to page 1788, please, within the National Executive Briefing paper. Draw your attention to option 3, which refers to a continuation of the current employer's strategy of partially descoping Intermass through direct awards for what are considered peripheral works, and it mentions the seafood restaurant. Do you see that?
Correct, I see that.
And it's correct that at this time it was your strategy to descope works from Intermass.
It was not my option, but they were not doing any work on that, and later we discovered why. It is because of the license. So the engineer decided to basically descope them and to bring somebody else to do the job. And we approached Tarakhis to get the approval, and Tarakhis did not allow 2 contractors to work on the job.
I just want to focus on the period at this time. So we're looking at 10th of August 2014, and Hill International have an understanding that your strategy at that time is to partially descope works from Intermass. My question to you is Hill International's understanding of your strategy at this time correct?
Correct.
If you look at option 4 below, it mentions termination of Intermass as a 4th option. If I could just ask you to turn over the page. And it's the 2nd paragraph down, so ignore the bullet point. 2nd paragraph down. You see that Hill International is reluctant to recommend termination of Intermass, as any incoming contractor would be delayed by the same unresolved design issues and inevitable complications with the payment status of existing subcontractors would add additional indeterminate delays to any projected completion date offered. So it's correct that Hill International are telling you at this time that replacing Intermass is not going to improve progress due to unresolved design issues. 1789 is the page I'm on.
Yes, yes. Your Honor, I'm looking at the date of this document because it's relevant.
The date of this report is, it's been sent to you on the 10th of August 2014, so because it's attached to the Hill International email sent by George.
The 10th of August.
2014.
Yes.
And my question was, if you look at that paragraph on page 1789, Hill International is telling you at this time that replacing Intermass is not going to improve progress due to unresolved design issues.
Correct. At that stage, there were design issues, but minor design issues, not major.
And also it's correct that Hill International are telling you that replacing Intermass would generate indeterminate delays to the completion date.
That's their opinion.
It's correct that Mr. Blow was dealing with NBAD to provide documents that NBAD required in order to satisfy conditions subsequent under the restatement. That's correct, isn't it?
Yes.
And you were not keeping track of what had been provided and what was outstanding at any one stage?
Correct.
You were aware that Intermass refused to sign Amendment Number 1 to the construction contract?
I am aware of that, yes.
And Amendment Number 2 to the construction contract was signed by you and Intermass, and it concerns an amendment to the contract price in the construction agreement, which moved it from around 267 million to 374 million. But it's correct that that Amendment Number 2 does not reflect any final agreement between you and Intermass on the contract price for the construction contract.
It reflected all the scope, not the scoping, all the scope of works that is basically given to Intermass and no de-scoping.
Sorry.
Yes.
But it doesn't reflect any final agreement between you and Intermass on the contract price.
As far as I'm concerned, that number is the final because it includes everything that was agreed with Intermass from the start. That's the complete project.
But it's correct that you continued to negotiate the contract price with Intermass well after you signed Amendment Number 2.
They were insisting on de-scoping themselves from other areas such as the food restaurants outside, which basically later we discovered they cannot do because of the restrictions on their license.
Which all has an impact on the contract price, that's correct.
Correct.
And that explains why you sent Amendments Number 3 to Intermass to amend the contract price again on 19 November 2014.
Correct. We were basically trying to get this work to be done by somebody else, and Intermass was not doing it.
And you also sent, Amendment Number 3 was not signed by either party, so that was not accepted, and that's a matter of fact. Then Mr. Blow sent Amendment Number 4 to Intermass on 7th of January 2015. That's correct.
Correct.
And that document was only signed by Intermass. You refused to sign that amendment, didn't you?
Because we did not want to de-scope them of the work.
We haven't.
And turn to tab 139. This is a letter from the engineer to Intermass dated 24th September 2014. First paragraph, it records that Intermass notified its intention to reduce the rate of progress of the works because of a lack of certification of extension of time, prolongation claims and variations. Then if we can turn over the page, at the bottom, the last paragraph, you see the the second line says, on behalf of the engineer, we consider the current manpower for the works provided by your subcontractor, JLW, to be completely insufficient and wholly incompatible with a target completion date of 31 March 2015. See that?
Yes.
And this letter is copied to you, isn't it? CC, you see your name at the
Yes.
bottom. So you were aware that the engineer was holding Intermass to a completion date of 31 March 2015.
That was based on the program given by Intermass.
And the engineer was holding them to that programme, which showed a completion date of 31 March 2015.
If they give the program, the engineer will stick to that program.
Okay, can I ask you to be given volume number 15, please? Tab 304. If I can ask you to turn to page 3248, please. Now, this is a letter from the engineer to Intermass, pursuant to clause 46.1 of the contract. Yes, it refers to clause 46.1 in the last paragraph, right at the end. And if we look at the second paragraph from the bottom, it says, this is to formally notify you that you have failed to coordinate, plan, resource and progress the works as described above sufficiently to achieve a rate of progress compatible with either project requirements or completion date of 31st March 2015. It goes on to say, be advised that you will be held fully accountable for any time and cost implications attributed to such delays, including the effects of any adverse impact caused to the employer, his agents and contractors by your direct and fundamental failure to comply with the requirements of clause 46. See that?
Yes.
Again, this is another example that the engineer is holding Intermass to a completion date of 31 March 2015.
Okay.
And there were many other similar letters from the engineer which were all copied to you, weren't there?
Correct.
We'll just go very quickly through those. If I can just ask you to turn to page 3244. This is a similar letter dated 16 October 2014. You see that?
Yes.
And if I can ask you to turn to page 3242. Again, this is a similar letter, which is now dated 16 October 20. Hang on a minute. I'm sorry. It's another letter dated 16 October 2014, and I ask you to turn to page 3236. This is another similar letter dated 26 November 2014. You see that?
Yes.
You see, the bottom of the first paragraph refers again to the completion date of 31st March 2015. And over the page, you see it's copied to you. Do you see that?
Yes.
So, if you had not read the restatement terms yourself, is it correct that you were not aware of your obligation in the restatement to notify NBAD immediately in writing if you or any of your technical advisors became aware of any delay to the construction timetable that is more than 60 days?
Can you repeat that, please?
Sorry. Were you aware of your obligation in the restatement to notify NBAD in writing if you became aware of any delay to the construction timetable of more than 60 days.
No, I'm not aware of that.
And there's no record of you notifying NBAD in writing that the completion date of 31 March 2015 was not achievable.
No, I was not communicating with NBAD on this matter.
Can I ask you to be given volume number 12, please? And if you could turn to tab 198. Turn over a couple of pages to page 2576. This is a utilisation request dated 12th of January 2015, and this is in a standard form of utilisation request that you signed. This is your signature at the bottom.
Correct.
Just want to draw your attention to the paragraph number 5 and B, which says, the repeating representations are true and accurate in all material respects by reference to the facts and circumstances subsisting as at the date hereof. That refers to the repeating representations in the restatement. Now, is it correct that you were not aware of what representations you were repeating by signing this letter and issuing it to NBAD?
I am not aware of any representation. This is a standard document that basically for drawdown, and I sign it every time.
You did not consider what repeating representations you were making by signing each of the utilisation requests?
Correct.
It's correct that in your negotiations with Intermas, in respect of their extension of time and prolongation, you did not reach any final agreement with Intermas on those claims.
We did not reach a final agreement, Your Honor.
If I can ask you to be given volume number 11, please. If I can ask you to turn over the page to page 2318. An email from Mr. Blow to Ms. Shocker of NBAD, copy to Mr. Sakon, which attaches your letter to Intermas, dated 16 December 2014. That letter, the attachment to that email, appears on the next page, 2318.1. This was your first and final offer to Intermas, wasn't it?
Correct.
It says, first and final offer from which DAS will not be negotiating.
Correct.
And if we go over the page to 2 pages to 2318.3, point 11 says this proposal remains valid for acceptance 7 days from the date of this letter. So this offer was due to expire on the 23rd December 2014. It's correct that this final offer was not accepted by Intermas.
Correct.
I'd like to talk a bit about the restriction on the Intermas licence. Now, the restriction on the licence dates back to 8 October 2013. That's correct, isn't it?
Correct.
And you first learned of that restriction on Intermas's licence in December 2014 as a result of the engineer's correspondence.
Correct, Your Honor.
And the reason for the restriction was never officially explained to you by Intermas or Trackies.
Intermas did not. Terachis, when I approached them, they explained it to me.
In your witness statement, you've said that the reason for the restriction was never officially explained to you by either Intermas or the relevant authorities. That's what you said. So that's not correct.
Explaining, I am not, talking about explaining why, what is the legal issues here. But the license states that they are restricted. And when I approached the Rakhis, they said it was restricted. And they didn't know why it was restricted. And we had to go to the Dubai Economic Department, and they said it was placed by the Dubai municipality.
Okay, if I can ask you in 11, which I think you still have, to tab 175. Just go to page 2331. You see, this is an email from Trackies to the engineer, dated 17 December 2014. And you see the subject heading, it relates to additional seafood restaurant. See that?
Yes.
Then page 2330, so going back a page, there are further emails from the engineer to Intermas on 23 and 28 December.
Yes.
And if we turn back a page again, 2329, we see here an engineer's letter to Intermas dated 30 December 2014, which is copied to you and Hill International. And then going back to the front of the tab, we have another letter from the engineer to Intermas dated 31 December 2014, which relates to this restriction on the Intermas licence. It's correct that we don't have any record of Intermas's reply to these letters from the engineer.
I did not see any response.
Okay. Funnel, can I ask you to turn to tab 184, please? This is the certificate of non-performance that the engineer issued on 29 January 2015. Correct that this certificate of non-performance makes no specific reference to the restriction on Intermas's licence.
Correct, as it reads, Your Honor.
And if we turn over the page to 2444, we look at what's enclosed with this letter, and it says supporting documents. And if we look at those documents, well, the first one are the notices issued pursuant to clause 46.1 of the contract, and then appendix 2 is the correspondence. So let's first look at appendix 1. So these are the clause 46 notices, and it's correct that in that list of letters there is no reference to the engineer's letters dated 30 December 2014 31 December 2014, which concerned the restriction on the Intermas licence. That's not listed. Those letters are not listed in Appendix 1, are they?
It is not listed, Your Honor, and I did not see reference to this particular item.
Okay, and if we look at Appendix 2 on page 2446, this is the correspondence list. Again, those letters from the engineer dated 30 and 31 December 2014 are not listed in the table, are they?
I don't see any reference to this.
Now, the first time you informed NBAD of the restriction on the Intermas licence was during the meeting with NBAD on 23 February 2015. That's correct, isn't it? And it's correct that at that meeting, NBAD asked you to revert back with evidence in support of what you told them about the restriction on the Intermass licence.
Correct.
The day after that meeting, it's correct that you obtained a letter from Trackies.
Correct.
And it's correct that let's have a look at it. It's staying in volume 11, tab 192. So we're just clear about which document we're talking about. So that's the translation. We have, I think, the Arabic version over the page. But it's correct that you obtained this letter specifically in order to show it to NBAD.
Correct.
And it's correct that you asked Trackies to reissue the same letter on 20 April 2015.
Correct. And that was also shown to NBAD, that they have done nothing.
Okay, if I can ask you to be given volume 13. In terms of tab 233. See that this is a letter from Intermass to NBAD, dated 7th of May 2015, and you see it's copied to you at the bottom. Do you see that?
Yeah.
And the letter states, last paragraph of the letter, Intermass emphatically confirms that it will have no difficulty whatsoever in completing the development known as the Langham Dubai Palm Jumeirah. And the the middle paragraph refers to what is enclosed, which is over the page. The Arabic version is on page 2778, which is a Dubai municipality document dated 6th of May 2015.
Yes, I see that. But
It's correct that you did not respond to NBAD on this letter from Intermass.
I did respond to.
Sorry, I don't understand that question. This is a letter from... I see. The question is, did you answer this letter? Okay.
Sorry, you were in the middle of your answer there, Mr. Almond.
The question was, I think, did you answer this letter?
This letter of Intermass is not addressed to me, Your Honor.
It's only copied to you.
It's copied to me. And the Dubai municipality, Your Honor, I've taken it to NBAD, and I said, Intermass should approach Trakhis, the relevant authority in here, not Dubai municipality. We have nothing to do with Dubai municipality. Dubai municipality is not in charge of permits on Palm Island.
Just to clarify, are you saying that you told that to NBAD verbally in
Yes.
response to this Dubai
Yes.
municipality letter?
Yes.
Given volume 15. To tab 295. See, this is a letter from Trackies, dated 30 January 2017. It's addressed to the DIFC courts. Dear DIFC courts, it's correct that you asked Trackies to write this letter addressed to the DIFC courts.
Correct.
Paragraph 3 says, the contractor Intermass was prevented from obtaining Trackies approval for the new seafood restaurant building due to the restriction remark placed by Dubai Municipality in a contractor licence at the time of submission. You see that?
I see that, yes.
So it's correct that this is only referring to the seafood restaurant.
The seafood restaurant was the only submission. There are other submissions that did not take place.
We've got no letter from Trackies or anyone else rejecting permission for work to take place on anything else other than the seafood restaurant. Is that correct?
Correct.
So let's just focus on the seafood restaurant for the moment. It's correct that you could have given the seafood restaurant works to another contractor.
No, that's not correct.
I ask you to be given volume number 7. And if we can turn to tab 74. See, this is EC Harris Commercial Due Diligence Report issued on 19 December 2013. So the issue date is on page 1363, just 2 pages over. And if I can ask you to turn on to page 1378. Draw your attention to the middle of the page, item number 4. Correct, that item number 4 is EC Harris recording that you informed them that Intermas will not be awarded the seafood restaurant.
That's correct.
It's correct that you...
Because they were basically delaying and delaying and delaying. And we approached, as I said to you, Terahis, to get another contractor to basically come on the project later. And the Terahis refused to have two contractors working on the project.
Let's be very clear about the timing, though. This EC Harris document is dated from 19 December 2013.
Correct.
So this is at a time when you had no awareness on your own evidence of the restriction on the Intermas licence.
Correct.
It's correct. At this time, EC Harris understand from you that you have told them that the seafood restaurant will not be awarded to Intermas.
Correct.
And they repeat that. I don't need to take you to it, but they repeat that in their later due diligence report, revision number 1. And just for the record, that appears in volume 7, tab 79, and page 1455. But I won't waste time taking you there. It says what it says. If I can ask you to go back to volume 9, please, tab 129. Going back to the Hill International Executive Briefing Paper, dated from 10th of August 2014, so let's be very clear about the date there. If I can ask you to turn to page 1788, which we've looked at before. As I mentioned previously, option 3, it refers to your current strategy of partially descoping Intermas through direct awards for what are considered peripheral works, seafood restaurant. So it's correct that as at this date, August 2014, Hill International understand that you still intend to descope the seafood restaurant works from Intermas's scope of works.
Correct.
Well, I think the point that's perhaps being put into is that you told me a short while ago that it was not possible to hive off the seafood restaurant from Intermas and put in some other contractor. So what is the position? As I understood it, you were planning just that.
Are you asking me, Your Honor?
I am.
We were not aware, Your Honor, that there were restrictions on Intermas license by the 8th of October 2013, and Intermas was not taking any action to basically construct this. So in the process, the engineer, Arif, decided to descope intermass of this and bring in some other contractor to work on the project. They have approached the authority, Tarakhis, and Tarakhis said, no, you cannot have two contractors working on the project.
Okay, I'll ask you that in due course. Thank you.
Start to go through a bit of the chronology in 2015 now. It's correct that you let the Hill International project manager contract expire on 28 February 2015.
Correct.
Then we'll move on to the meeting with NBAD on 23 February 2015. And if I can just ask you to be given volume number 12, in terms of tab 194. Over the page, 2 pages, page 2560. Third bullet point below if you find the first hole punch, the upper hole punch, 3 bullet points down, you've got, it begins on 23 February 2015. That's NBAD's minutes of the discussions at that meeting on the 23rd February 2015. I just want to confirm with you that it's correct that you did not take your own note of the discussions that took place at that meeting.
I did not take notes on the meeting, correct?
And it's correct that the NBAD note records that NBAD told you that termination of Intermat would lead to arbitration.
No, that's not correct.
You're saying this minute here is not correct
Correct.
in respect of what Mr. Abdul Haq told you. So where is the bullet point below, it says, Mr. Samet explained that a notice of termination would provoke Intermas to obtain an injunction through the court of first instance and engage in arbitration. Now you're saying that minute is not correct.
That is correct.
Okay. In any event, it is correct that Intermas did commence arbitration against you after the construction contract was terminated.
Correct.
And in that same bullet point, the second to last sentence, it records that Mr. Abdul Haq told you that while these arbitration proceedings or legal proceedings are going on, this would bring the project to a complete standstill and admitting a new contractor will be impossible. Is that minute correct?
I do not recall him saying that.
Okay. But it's correct that after the construction contract was terminated, you were in a poor negotiating position with respect to potential replacement contractors.
Sorry, repeat that question. I did not understand.
Sorry, I'll repeat. After the construction contract was terminated, so this happened in June 2015, it's correct that once it had been terminated, you were in a poor negotiating position with respect to potential replacement contractors.
You said poor?
Bad negotiating position. You didn't have much leverage.
No, that is not correct. We have identified a qualified first-class contractor who has built 16 plus hotels, and they came, Your Honor, to the project determined to finish it. And they carried the work of assessment for a couple of months, and they basically made an offer to complete that project.
Let me just confirm. So, you, in answer to my question, you disagree with my proposition that you were in a poor negotiating position with potential replacement contractors?
Yes, I disagree with you.
Can I ask you to be given volume number 14, please? And if I can ask you to turn to tab 281. If I could just ask you to turn to page 3099. See, this is an email from Mr. Delcousis of DLA dated 11 November 2015. And here he is providing comments on the proposed contractual documents between you and ALEC, so your proposed replacement contractor. And if you see at item number 2, he says, both DAS and DLA recognise that as a general comment, the risk allocation reflected in those documents are weighted more heavily against DAS than would be the case at the beginning of a project in a competitive tender situation. That result is a consequence of the poor negotiating position that DAS is presently in, with no alternative contractors to negotiate with in order to keep ALEC honest, so to speak. So it's correct that by this time, so November 2015, your lawyer is accurately reporting that both you and DLA recognise that you are in a poor negotiating position with respect to replacement contractors.
That is the opinion of the lawyers.
So your lawyer was incorrect in saying that it was your opinion as well?
My opinion, okay, is that I have found a first-class contractor who will finish the job. And it is very difficult to find a contractor to take over, Your Honor, a job that is not finished.
So you at least accept that it was harder to get a replacement contractor to take on an incomplete?
Naturally.
We can go back to the NBAD minute of that meeting on the 23rd of February, so that's volume 12, tab 194. Page 2560. Page 2560. If you start with the lower hole punch, and it's the second bullet point up, and that's it's still within the minutes of the discussions of the meeting on 23 February 2015. You see here the minute records. We, so NBAD, reiterated that the existing delays and pending conditions subsequent constitute a breach of the restructure agreement and stress that loan drawdowns are at a halt till a clear strategy forward is in place. Now, do you accept that that is an accurate minute of what was discussed in that meeting?
Absolutely not.
Staying in the same bundle, can I ask you to turn to tab 201?
Well, I know. Was there no discussion about delay?
Your Honor, I recall clearly that I came to see Mr. Antoine and Ms. Abu Shoka, and they asked me to go to the 16th floor to see Mr. Samer. I did go there, and as we entered the meeting, the only person who spoke during the entire meeting was Mr. Samer. The rest of the two were silent. And he stated clearly that he doesn't know who's Intermas without being asked. So no discussion on conditions subsequent has ever taken place with anyone, Your Honor. No one has brought conditions subsequent discussions to me or wrote to me for that fact. I've never had discussion with anyone on conditions subsequent.
Was there a discussion about delay?
The discussion on the delay has always been the discussion of Intermas, has always been there. I thought I was determined, and I said that during the meeting, Your Honor, that I want termination of Intermas.
Did Mr. Samer say anything about loan drawdowns being at a halt.
Yes, that was said before the meeting, and I was aware of it, and he stated that during the meeting.
And did he say anything about what would give rise to a release or a renewal of loan drawdowns?
There was no condition such as that at that time, Your Honor, because I was adamant and insisting on termination.
I'm not sure I asked my question very clearly. Did he say anything about the circumstances in which the loan drawdowns would no longer be at a halt?
No, he did not discuss that, Your Honor.
Okay, thank you.
Okay, if I can ask you to turn to tab 201, same bundle. This is a memorandum which records a discussion that you had with Mr. Sokon. And I'll just draw your attention to paragraph 2A, 2A, which says status quo situation. If you just read that.
Yes.
Recall that Mr. Sokon warned you that the failure to resolve the dispute with Intermass and no tangible progress on the project may lead to a classification of your account.
No, I don't recall that.
You don't recall Mr. Sokon warning you that the status quo situation, if it continued, may lead to NBAD enforcing its rights, including foreclosure on the project.
By the date of this internal memo or call memo, no.
Then item 2B, sale. Is it correct that you told NBAD that you had received offers to purchase the partially completed hotel?
That is not correct because I've never wished to sell, Your Honor, a partially finished hotel.
So the person who's drafting these minutes of your discussions with NBAD is just getting these discussions completely wrong. Is that your evidence?
Yes.
If we go over the page to the last section, conclusion and action plan, here it records, we requested to have a final action plan to be submitted by client by 19 March 2015. Mr. Musaba confirmed that he will submit his plan by this target date and reassured that he wants to finish the project as soon as possible. Is it correct that you promised NBAD on this date that you would submit a full proposal to NBAD with a programme of works and a development budget?
That is not correct.
And E, just above, it says project payments. Is it correct that you were told that it will be difficult to permit utilisation of the loan to continue given the absence of a clear project strategy?
Correct.
That was discussed.
Yes.
Okay. So you accept the minutes is accurate, at least in that respect?
Yes.
Then it goes on to say, he confirmed that he has instructed the project engineer not to certify any project payments till an agreement is reached with NBAD. Now, is that minute correct?
Correct.
That was said by you. Okay. If we go over to tab 202, and this appears in landscape, this is invitation from NBAD, dated 15 March 2015, for you to attend a meeting with NBAD, Intermass and EC Harris on 19 March 2015. And this date, 19 March 2015, so the proposed date for this meeting is the date that's recorded in that minute we just looked at as the deadline for you to submit your final action plan. That's just the fact. It's 19 March 2015 is the date, and the minute records that that's the date when you were going to, or when you said, when the minute records that you said you would provide your action plan. It's correct that you refused to attend any meeting with NBAD and Intermass in attendance.
Correct.
You can go to tab 207.
Take a break when it suits you.
Now is convenient, Your Honour.
Okay. We'll just take 10 minutes. Okay. Thank you.
All rise.